Hi, Ramini here. In Chapter 3 of They Left No Crime Uncommitted, the author explains the judicial act of piracy called in Rem Forfeiture. These civil forfeiture laws are the antithesis of justice and fairness, as you will see. No civilized society should be stealing property and charging the property with a crime. A lawful government is supposed to protect the rights and property of the citizens, not to steal everything they own. Its proper function has been turned upside down. The government is not protecting our rights, not guarding the borders, not controlling inflation, not allowing free medical choice, and not allowing free speech without being terrorized. As the late George Carlin said, they've got you by the balls. Thankfully, many people now realize the federal government has outlived its usefulness, assuming it ever had any.
Chapter 3. The Rem Seizure Scam. It wasn't long before I was called to the attorney consultation room at Bibb County Jail. Unfortunately, it was not an attorney visit, but an unwelcome visit by Ted Robertson and another IRS crony. Robertson, the highwayman, who engineered the pretextual roadside arrest and the pretextual search of my home, had another little surprise for me. A list of those items taken from my home that he chose to report on the inventory and official notification that the already seized property was now arrested. In other words, the property itself was accused of mail fraud and money laundering. This was my introduction to one of the most tyrannical laws in America, the in rem civil forfeiture statute. Its historical roots come from the despised English Admiralty laws used to arbitrarily seize maritime property, vessels and cargo, from the colonists and forfeit it to the Crown. Congress has resurrected this despotic practice by bringing Admiralty law to land. At first, the in rem forfeitures on land were restricted to the seizure of property involved in drug crimes. It was pushed through Congress as a means of winning the unwinnable war on drugs, including CIA-smuggled drugs, but was really a revenue measure all along. As planned, congressional conspirators soon expanded in rem forfeiture to many other crimes, which once again proves that if you give the government 1 inch they'll take 100 miles. An in rem forfeiture action is different than a criminal forfeiture. In a criminal forfeiture the government must prove that you are guilty of a crime beyond a reasonable doubt by convicting you in a jury trial. An in rem forfeiture, on the other hand, is a civil suit based on the legal fiction that the inanimate property has committed a crime. The property can be arrested and convicted without the owner ever being charged or convicted of a crime or even attending the civil trial. All that is required for your property to be arrested is for a lying government official to assert his belief that probable cause exists that the property was used, or intended to be used, in any manner or part to facilitate the commission of a crime. Moreover, this belief can be based completely on hearsay, gossip, or malicious rumor. And in the 11th Circuit, Alabama, Florida, and Georgia, and other circuits, the arrest warrant for your property can be issued by a lowly court clerk instead of a judge. In fact, it was a pencil-pushing court clerk who issued the arrest warrant for the property itself. This was after it was seized weeks earlier. Like the search warrant, the in rem arrest warrant for my property was likewise based on Robertson's self-serving belief. That is, he believed the books had, quote, little or no informational value, close quote, that I used models in my advertising, made unrealistic earnings claims and impossible guarantees, and his completely false claim that I wasn't filling book orders. Robertson later admitted that he'd never read a single book. All this was merely his belief. Once a civil in rem forfeiture action is filed, you have the burden of proving the property is innocent of a crime. The government doesn't have to prove anything. Of course, when all your assets are seized, you won't be able to hire an attorney to prove your claim in court. And since it is a civil action, you are not entitled to a free court-appointed attorney to assist you in reclaiming it. You only get a free attorney if you are charged with a crime, not when your property is charged with a crime. Thus, acting alone, and without any legal training, a pauperized defendant must file a claim of ownership within 10 to 20 days of notice in order to contest the forfeiture. Then, if you want the property returned pending the civil trial, you must post a cash bond of 10% of the value of the property. Of course you can't do that when they steal all your assets. Lastly, if the property is damaged or completely destroyed while in the government's custody, too bad, you can't sue for damages. The deck is stacked against you. What kind of crappy justice system is this? I managed to mail the court a handwritten claim for my property from my jail cell within the 20 days, though Robertson and his henchmen expected me not to. I couldn't afford an attorney or post a 10% cash bond since they seized all my property. But if there had been other assets, then they would have been seized as soon as I tried to use them. The government, meaning the dirtbag prosecutors hiding behind the facade of lawful government, reacted to my handwritten claim by promptly filing a motion to stay the civil forfeiture proceedings. This was to deny me access to my property pending a criminal trial against me for mail fraud and money laundering. It was pending for 3 years because they had to figure out how to manufacture a criminal case. The bottom line is the prosecutors expected that I would not file a claim on the property, and it would be theirs by default. So there I sat, thrown in jail, pauperized, denied bail, denied due process, and denied a lawyer. With these resources, I had to somehow prepare for my 2 upcoming fair trials.